getting right to the subject, we're just going to talk about some basic estate planning things and some points that I think everyone should know, and you may already know them. And if you do, I apologize. But and if you have a question, go ahead and interrupt. I'll just make things shorter when it looks like I'm running out of time. So I want to start out. Let's see. I better figure out my. There we go. I came up with this just in preparation for today's presentation. Estate planning is a process wherein you identify a person's goals and variables unique to each person's situation and determine and utilize tools that can best be used to reach those goals. Now, you may not realize that if you already have a will and you've been to your attorney for estate planning, but if your attorney did a really good job, that he or she was able to identify your goals in one of the early, either looking through your a questionnaire that you might have received or in an early conversation that you might have had with the attorney. But there are several reasons that people do not do estate planning. As Woody Allen put it, I'm not afraid to die, I just don't want to be there when it happens. And so that's kind of denial, and we see that a lot. It comes to reality when you're in the hospital and you're 90 years old and in terrible condition. But a lot of people deny it right up to that point. Lack of knowledge is another one. By that I mean you just don't know what to do. Where do you get started? I ought to do it, but I don't know how to do it. Age is an issue, and that's usually on the underside. Young people never die, and if you don't believe it, just ask them. And so they're not thinking about it, and it's just not high on their priority list. And then, of course, there's just procrastination. Oh, I've got to do that. I got a call at a seminar in November. I was in Kansas City, and the woman was going on vacation, and she had to have this document done tomorrow. Well, she was in Des Moines. I said, I can't do it. Well, email me when you get back and tell me how much it's going to cost and everything. And so I did. And now, this week, she's going out of town next week. And she called me again and said, I got to get this done. Well, that's procrastination. As if any of us needed a definition for procrastination. Intestate succession means dying without a will. It's a term of art, but probably all of you have heard it. And I tell people the intestate succession law suits people who are unmarried with no children and no property. Now, how many people are here in the room that are unmarried with no children and no property? I see no hands. And that generally means it doesn't suit anyone, really. I set this up the other night, and it got fancier than I wanted it to, so it just kind of has a mind of its own. I have to keep pushing buttons. Having no plan at all, what are the effects of that? The effects, first of all, if you have a common disaster with your spouse, the first person to die has disinherited their entire family, and everything passes to the family of the surviving spouse if you have no will. The second thing that you might think about is a widowed person. And maybe you've been widowed more than 10 seconds, like in the common disaster. You may have been widowed for several years. But you always said, well, in fact, my father, for instance, is closer probably to my mother's side than he is to his own side in many ways. And he wouldn't want to disinherit my mother's side if there were no children, for instance. And so, in effect, a lot of people would say, well, I want half to go to my spouse's side and half to go to my side. But without a will, it's all going to go to your side. You have a single person with well, I need to hit my button here, don't I? There we go. You have a single person with no children. The assets are going to pass to their parents. And that may seem like a logical thing, and it may seem like a good thing. But the problem is that the assets may pass to, I said older parents, it should be aged parents. And the parents may not need the assets. In other words, they have enough of their own to live on. They may not want the assets. If they receive them, they may be very wealthy. They receive the assets, and so they're in an estate tax situation, and anything they get from a child or from you are just going to add to the tax problems when they die, maybe in a few years. and they may not get it. On the other end of the spectrum, they may be on Title 19, and receiving an inheritance from anybody is going to disqualify them from Title 19 benefits, at least for a time, until they spend down to the amount of money required to put them back on Title 19. So, in effect, you're just passing it on to the government in that kind of a situation. Now, children may be treated or will be treated equally in an intestate situation. And your first reaction is, well, that's good. I want my children to be treated equally. But the fact of the matter is that your children's needs may not be equal. There may be an age disparity. The older child is in a medical practice, and the younger child is struggling to get out of high school and maybe in the same accident that took your life and is disabled because of that accident. Well, their needs are disparate. They may have a different surviving parent. You can kind of figure that one out. The deceased person has two children, but by different parents. And so one parent is wealthy, one surviving parent is wealthy, the other surviving parent is not wealthy. And so again, the deceased person's assets are not go equally to the two of them, and that's may not be what you want. One child may be disabled. And again, going back to the previous slide, the children may not need it, they may not want it, and they may not get it for those same reasons that we talked about back there. Without a will, you may have increased court costs and attorney fees. For instance, if you own real estate, the law of the state of Iowa does not give your administrator the power to sell property without approval of the court. Generally, you're looking at $500 to $1,000 to go to court to get permission to sell your real estate. A will probably doesn't cost that much. And in the will, you say, I give my executor power to sell my real estate. And you don't have to go to court. They just sign a purchase agreement and list it or go out and sell it on their own or whatever. And so you've saved the cost of the will just by that one paragraph. And by the way, you need to make sure that paragraph's in there if you go to an attorney that doesn't have that in there. The estate tax effect may be worsened if you don't have a will, because if you're familiar with estate tax law, you get a 100% marital deduction for estate tax purposes. But if the surviving spouse, if you haven't set up a plan so that you can use the surviving spouse's marital deduction, I'll put it that way, then you have perhaps put up to $2 million at risk of estate tax, whereas if you had a will, you can protect $2 million, well, up to $4 million for a couple, whereas in a case of a surviving spouse, you can only protect $2 million. So there may be an adverse estate tax effect. You have no right to name your successors if you don't have a will. An executor is the person to handle your affairs, and without a will, the court will appoint someone without your input. Now, if you have one child, for instance, that's probably not a problem. That child's going to go in and be appointed as your administrator. But if you have no children, or if you have 10 children, you haven't had a say in which person you want to handle your affairs. For younger people, if you have minor children, you can name guardians for your children in your will. And again, without a will, you have no say in who's going to be the guardian for those children. I had a case one time where there was literally a road race. I was in the Air Force at Offutt Air Force Base. One family side came from Texas. The other side came from Louisiana after a couple was killed in an automobile accident in Omaha. And the first to arrive got the kids. And the second, they took them back to, I don't remember if it was Texas or Louisiana, and took them back. The second family arrived and said, well, where are the kids? And the Air Force was a little sheepish, but had to say, well, sorry, they went to Texas. And I don't know how that came out, but do I have to know how it came out? It's a problem, obviously. Not only do we not know the intention, but we don't even know where the kids are at this point. A conservator, without a will, a conservator would be appointed for a minor person, and the minor person would receive their entire share at age 18. Ordinarily, people don't want their minor survivors receiving all of their share at age 18. With a will, you can postpone that to 21 very easily, and you can postpone it to any age you want without any difficulty if you have a will. So, going back to our process, estate planning is a process where you identify your goals. So what are your goals, and what's the importance of planning the succession of your assets? First of all, you want good stewardship. Most people want to have good stewardship of their assets, and this is just putting it on a human qualitative basis. You've taken care of what you have during your lifetime. You probably want to take care of what you have as best you can when you're gone. You want to know, or you want to think about how to distribute the property, and you say, well, duh, that's obvious. That's what a will is all about. But I have had people come in fact, it's a regular occurrence, and you get down to, at some point, and I say, all right, how do you want to distribute whatever? And he looks at her, and she looks at him, and, well, we have a little dispute about this. And so you need to iron those things out, preferably before you go to your lawyer. But we can help you do that. Also, we can help facilitate that process. But that's where we learn your goals. Well, what's the issue, and why is it that you have this problem? Is there an alcoholic among your descendants, or a disabled person among your descendants, or a spendthrift, a person who can't handle money among your descendants, or somebody who you just have some problems with? Tax avoidance and savings can be helped. I've already mentioned the fact that you can easily protect $4 million in the case of a married couple. That's twice as much as you can protect from estate taxes if you're a single person. And there are things we can do above the $4 million mark for those that have more assets, if you have a will and if you think about it ahead of time and if you do that planning. And again, appoint persons to carry on in your absence, and we'll come back to that while you're living in a few minutes, but primarily the will would cover what happens when you're gone. Again, the executor, the guardian, conservator, or a custodian for your children. And then, of course, you have the avoidance of surprise, and there's nothing I hate worse than having surprised clients. And you can tell that these people are surprised because as they're reading the will, it starts out, I, Emperor Dwayne VI of Nebraska, being of sound mind. And they're also already seeing that, I think we got a problem here. Incidentally, people ask, well, when are we going to have the reading of the will? And I've been practicing since 1972, and we've had a reading of the will once so far. If people want to read the will, I send them a copy. And I think usually your attorney, in the case of a deceased person, will just send you a copy if you want one. But in any event, avoiding surprise is real important for your descendants and your beneficiaries. So you identify the variables that are unique to your situation. What is it that about your situation that affects your goals? What are the roadblocks, for instance, in our estate planning process? And then you have to determine the tools that can best be used to reach those goals. And I'm going to talk about various estate planning tools. The first one is a promise and a prayer. I just kind of made that up, but I've heard it. I'll just give it to my oldest son. He'll know what to do with it. Well, he may know what to do with it, but whether or not he does it is a different thing. And it's fraught with all kinds of problems, obviously. Joint tenancy is a popular estate planning tool. We recommend joint tenancy for your house. And if you had, I suppose, a relatively small farm, or maybe you had several farms and you lived on one of them and it's a relatively modest part of your estate, joint tenancy basically says that you each own all of it. And so with a joint tenancy situation, it passes automatically to the survivor. Now, again, if you're living in town and you have a house, or it doesn't matter if you're living in town or not, you just have your house in joint tenancy. That's probably a good idea because you want your spouse to be able to live in the house unless you get into some sophisticated estate planning techniques. But if you have a $4 million farm, and I've already said you can protect $2 million of that at the death of each of the people that die, and that passes automatically to the survivor of you, it's gone right around the will. And so now you're back in the situation where you had no will at all as far as tax planning is concerned. Because the survivor has $4 million in her estate, and she can only protect $2 million from estate tax without using what we call the applicable exclusion amount of the first to die. So joint tenancy isn't always a good idea for tax reasons. Just for the most typical example that I use, or the example I use most typically, I guess I would say, you're in an automobile accident, and the truck hits from the driver's side of the vehicle. The driver is killed instantly. By the time the truck gets over to the passenger's side of the vehicle, the passenger has inherited everything from the person on the driver's side of the vehicle because it was in joint tenancy and he died first. And so now you have all the questions that we had maybe without a will. It passes under the survivor's, the quote-unquote survivor's will, the passenger's will, or it passes intestate to the passenger's family. And you've entirely eliminated the driver's heirs as beneficiaries of the joint assets. Now that's an extreme example, obviously. But suppose the passenger lives for a week or a month or a year, it's the same effect. The point is that a joint tenancy goes around your will. There are investment instruments, and you can name in certain instruments pay on death. I think you generally would see those in a checking account, or not necessarily a checking account, but a bank account, a CD. In fact, if you go to the bank, they will volunteer that you ought to have this on POD. That way it passes automatically to your survivor, and that always sounds good. I have an office in the bank out in Johnston, and I have had people literally get up from my desk where I've told them, don't do anything that will take this out of your will, and they go down around the corner into the bank and set up a POD account. And a POD account is just like a joint tenancy account. It passes automatically to the person you've named. And it goes right around the will or the trust that you've set up in my office. A transfer on death is usually a broker situation. It's same meaning, same effect, passes automatically at death to the person that you name. Life estates are another example. I have a lot of people come in and they say, well, it was so simple when my parents died. It was just in a life estate for me. And upon more careful discussion, I find out, well, maybe the person's parents had only one child, and maybe it works in that case. Whereas now we have 10 children, and we have a life estate involved, and a lot of times we see it pass to the surviving spouse who isn't the mother of the children. And so now who's taking care of the asset? Who's shingling the house? Who's making sure that there's a new furnace or good siding on it? Probably the surviving spouse doesn't care because she's just living there for life. The children don't want to put their money into it to put a new roof on the house, even though they are going to get it someday, but they're already 65 years old themselves, and they have to dip into their own pocket to roof a house that they may or may not ever have any part in. So those are kind of some of the problems that are incumbent with a life estate. Basically, nobody's in charge. It's very simple. And as far as stewardship of assets, you want somebody to be in charge of your assets. And so rather than a life estate, you put it in a trust, and you have somebody in charge. You may have some assets that can pay for those improvements to the house, and then it passes according to the trust. I've already talked about joint tenancy. It looks like I got ahead of myself, so that's good. We'll just go right on. Joint tenancy is not a replacement of a trust. Joint tenancy with a non-spouse, that I usually think is very bad, or at least not good. Again, the survivor takes all. A lot of times we'll have, this goes back to what was it? a promise and a prayer. Well, I'll just put the house in my name with my son, and when I'm gone, he'll sell the house and divide it up among the kids. Well, that may or may not work. If the son is driving around with the father or with the parent, and they're in a common disaster, and the son survives by a few minutes, it passes under his will to his wife or to his children, and they haven't made that promise, and they haven't even heard about the prayer. So it's out of your control again in that kind of a situation. If, on the other hand, the son dies first and it's back to the parent, well, now it goes under their will, but if we're using joint tenancy as a substitute for a will, then it's not going to probably go the way you want it to go. The family of the first to die is disinherited. We've already talked about that. The non-joint tenants are disinherited. In other words, with one child, but the other children are out. And again, we've covered all these things. Inheritance tax may be owed if it goes. In Iowa, there's no inheritance tax between and among ascendants and descendants. So if you die and it goes to your parents, or you die and it goes to your children, there's no inheritance tax. But if it goes to a niece or a nephew, or let's see, a step grandchild, or an in-law, daughter-in-law, son-in-law, you're going to have inheritance tax. And so that may not be part of the plan with joint when you set up the joint tenancy, but that could be the effect. What do you do, though, if you want somebody to sign for you at the bank? I'm going to put both names on it just so son can sign for me if I need to. Well, it turns out son doesn't very often have to, but if you need to, you want to. Well, if you go to the bank and ask them about accommodation signers, they will, almost every bank has that arrangement. They just forget to tell you when you come in, and you can have an accommodation signer on your checking account, for instance, and that person can sign on your behalf, but it doesn't go to them when you die. And you avoid all the problems with joint tenancy, and yet you have the assurance that somebody else can handle these things for you if needed. You can also do a power of attorney, naming a certain person to handle your affairs for you. That power of attorney can be effective immediately, or it can go into effect in the event of your disability. And again, I mentioned that TOD and POD are the same as joint tenancy. Already covered life estates, so we can go past that, I believe. Some of the problems with life estates when you set it up. This one I didn't mention. Things may change over the life of the life estate life tenant. The value may change dramatically. It may go up or it may go down, but it wasn't part of your plan. The income of the various people may change. Someone may suddenly become wealthy. Somebody is not so wealthy or becomes less wealthy or impoverished. The health situation of the people change. A lot of times we see, again, that surviving spouse going into a nursing home, but she's got the house for her lifetime, which that's what a life estate is. So now there sits the house. Okay, so can we rent the house? Well, who's going to rent the house? Nobody's in charge. If you rent the house, where does the rent go? Well, I go out and rent the house, but the rent all goes to my stepmother. So you have all those kinds of things. And, oh, yes, my wife loves the children just as if they were her own. Never mind, she's only 2 years older than they are, but nevertheless, well, that relationship may change after the death of the owner of the property. A life estate, well, can it be sold? Yes, it can, but have you ever put a life estate on the market? Who's going to buy a life estate? It may last for 20 or 30 years, or you may sign it and pick up the newspaper and see the life tenant's obituary in the paper the next day, and you owned it for a day. So what is it worth to anyone? Maybe you can sell it to a family member there would be some interplay in relationships there. And again, you have the Title 19 issues. The value at the date of death may be different than it was during the life, and the assets that the person has may be different, and suddenly the spouse is impoverished. And interestingly enough, you may find this hard to believe, but the IRS thinks that the life estate is not worth very much when you die. In fact, if you're dead, what is a life estate worth? Zero, right? However, Title 19 people think, well, that life estate's worth a lot when you died. Never mind that you're dead now. We're going to look at it on the day that you died and take your life expectancy. And even if the IRS did that, the Title 19 people think it's a lot longer life. They use a different table. And so a dead person yesterday had a lot longer life expectancy for purposes of Title 19 than the dead person yesterday did for IRS purposes. Don't even try to figure that out. Talk about a will. What are some good ways to plan? There are three kinds of wills. I have people call me and tell me I just need a simple will. Well, whether or not you need a simple will, at least that's one of the possibilities. Everything to my spouse, and if my spouse predeceases me, then to my children equally. Per stirpes and not per capita. Those are some words, some fancy words that we use to cut down the wording in the will, and it means that if one of my children is predeceased, that person's share passes to that predeceased child's children as opposed to my other surviving children. Per capita would be add up my surviving children and divide it among them, or you could even include grandchildren and divide it among them, but that wouldn't be right. Generally people want the predeceased child's share to go to that person's children. So that's a simple will. A contingent trust will you often see with people who have minor children, and that says everything to my spouse, and if my spouse isn't living, put it in a trust for my minor children until they reach a certain age. That age, again, can be any age, but usually you want it more than the law would provide otherwise, which is 18. It can be 21, it can be 25, it can be 30, it can be various ages, 1/3 to be distributed when the children reach age 23, 1/2 when they reach age 27, and the balance when they reach age 30. That gives them usually a maturing process, at least theoretically. And the third kind of trust that's most common is what we call a two-trust marital deduction will, and that's also known as an AB trust. And this is for people who have estate tax issues. And I talked about the exemption amount of $2 million and the marital deduction that the spouse can have, and then the spouse can use her marital deduction, the surviving spouse can use her applicable exclusion amount, and you can shelter up to $4 million. It's a pretty simple trust or a will, but if you saw the form, you wouldn't think it was. But it's not very complicated to put together if you have an attorney that knows what they're doing. But those basically are the three kinds of wills. A trust, on the other hand, people a lot of times will say, well, what is a trust? And a trust is a contractual relationship where a first party, the grantor, transfers assets to the second party, the trustee, for the benefit of the third party, the beneficiary. And you start out with a living trust. Guess what? All those people are the same people. The grantor sets it up, appoints himself as trustee, and has it for the benefit of themselves until they become disabled or for the rest of their lives. And then it passes on to their children. The advantage is that it passes without court interference or involvement, and you usually save some expenses at that point. One of the disadvantages is it costs a little bit more because you're setting it up during your lifetime, and there are certain people that would benefit from it, and certain people who maybe not. I generally recommend it for older people, older people. I mean, at least in their mid-70s. Single people, again, older and single. People with property in another state. If you have property in real estate, in two different states, and you want to at least avoid probate in one of those states, you should set up a trust and put your out-of-state property into trust, so you're not having to probate the property in two states, or probate your estate in two different states. And then people who have disabled children might want to set up a trust so that their disabled child can have continuity with just a changing of trustee in the event of something happens to the parent. And I also recommend them to people who come in and say, I've read up on trusts and I want one. That's pretty easy. I'll give you a trust. It's not a problem. You can set those up during your lifetime. As I was talking, you can set one up in your will, and that goes back to that AB marital trust will. They can be revocable. You can shut them down whenever you want to. Some situations you might want them to be irrevocable, and that would be usually a tax planning issue when you're trying to remove assets from your estate to get down to the $2 or $4 million level, and you want to get this asset out of your estate. You can put it in a trust, make it an irrevocable trust, and you have some tax savings. You set the trust up, we're going to go to advanced directives now. Advanced directives are set up during your lifetime to be effective in the event of disability before death. And here's a couple, and he's saying, just so you know, I never want to live in a vegetative state dependent on some machine. If that ever happens, just unplug me. Okay, she says, and she unplugs him. Now that's an advanced directive, but maybe not what he had in mind. But these are the typical advanced directives that we offer to our clients. Living will is one that everyone is probably familiar with. I call it the pull the plug kind of a document, and that says if you're in a terminal condition with no hope of recovery and you can't make the decision yourself, you're expressing your intention that you do not want your life sustained by life-sustaining procedures. I've had people say, does that work? I respond, I don't care if it works. The point is you're communicating with people, and a lot of times people just don't communicate. I've had clients say, well, I never really knew, we pulled the plug, but I never really knew what mom wanted. Well, it's because mom never communicated it. If you have a living will, at least you've got that communication out there. Now, in fact, I think they usually do work to most people's satisfaction. The next one is a standby power of attorney, and there are two different kinds, and I put them together a lot of times for my clients. But you have a healthcare power of attorney, goes into effect in the event of your disability, and you name someone to serve on your behalf to make healthcare decisions. It would be nursing home decisions. It would be anything relating to your personal affairs, basically, as far as where you live and how you're taken care of and so forth. The financial power of attorney can, like I say, be the same document, or it can be a separate document. It can be different people. But the financial power of attorney, the person appointed takes care of your financial matters. That can be effective immediately. I don't usually recommend that for various reasons, but it can also be effective in the event of disability. And that is when we most often do it. Recommend that for everybody. And whether or not they really want it, that's our recommendation. They come in and they say, well, I want a simple will, but they haven't thought about these kinds of things. Standby guardianship or conservatorship. A guardian is a guardian of your person. A conservator is a guardian of your property. And standby means, again, it goes into effect in the event of your disability. So you really sign a petition now saying that if I become disabled, I want son 1 to be my guardian or conservator or whatever. Now, why would you need that if you have a power of attorney? I don't know why you need it, except that we've had people say, well, this power of attorney is 5 years old. Well, yeah, that's the idea. It's supposed to last as long as the person's disabled. But the issue is, well, how long are we going to honor a power of attorney? You could sell the house, and you go to your buyer's attorney could examine the abstract and say, well, that's a great power of attorney, but I want somebody to sign because I know there's trouble here, whatever the reason is. So you appoint a guardian, you appoint a conservator to deal with these issues. We really don't charge any significant amount more. It's all just entering some information into the computer and printing out a couple more pages. Organ donation is another issue. That's an advanced directive. We have a little paper we have people sign, but you should, if you really want to be an organ donor, you should go to, I don't know the name of it, Iowa Organ, I'm sorry, can't say the name of it. It's online, or you can get a card, organdonor.com. That's not it. But anyway, that's an advanced directive that you might want to think about. Some people want to donate their bodies to science. Some people want burial and funeral instructions. And so in any event, the process, again, we go back, we've got all these things, we've determined what tools can be used, and we utilize those tools. And then finally, how do you utilize those tools? If my wife sends me out to the grocery store to get a pork chop, I don't go looking for a pregnant hog. I go to the grocery store, And so I wouldn't expect you to go out and create your own will, just like I wouldn't go out and create my own sow and pig and raise it to get my meat. What about will forms? This is one I actually had. I give, devise, and bequeath to my, and I filled in the blank, beloved wife, Norma H. Smith, if he, she, it, whichever the case may be, will survive me. Well, you know, that works, but it's a little impersonal to call your beloved wife he, she, or an it, whichever the case may be. You're really not doing the estate planning process when you're doing this. You bypass the goal the goal identification. You bypass the process of determining which of these tools are the best ones, and you know it can be just dangerous. And this is my favorite cartoon. This is the Schultz brothers buck and cut. Okay, and look at the fellow there coming out of the Schultz brothers buck and cut. He is disgusted, isn't he? He's got a Band-Aid on his chin, and look at his haircut. It's absolutely terrible. However, rewind a few minutes, and who walked into Schultz Brothers Buck and Cut in the first place? And did he know what he was getting into when he went in there? It's right there on the window. Big open window. You can see inside that they're riding bucking horses. And then look, he's got to deposit 25 cents to make it buck. Okay? That's kind of what you're doing if you're seeking estate planning assistance without an expert. And by that, I mean someone who really knows what they're doing. I know a lot of you probably are from small towns, and there are a lot of good probate and estate planning lawyers in small towns. And there are many of them that are my friends, and we are in the probate section. If you find someone who's active in the probate section of the Iowa Bar Association, you probably have somebody who's really good. On the other hand, that's all I do. And I don't do anything but probate and estate planning, and that is the level of expert sometimes you may want to call on. On the other end of the spectrum, there are people who, well, I bought a house and I had this attorney handle my real estate deal, so I'll just go to them for my will. Well, that's really the other end of the spectrum. You don't know anything about what the person does, and or what their expertise is. And when you call and say, I just want a simple will, you may get just a simple will, and that may be not what you need. So, any questions? We're right on the button. Amazing. Yes? The question is, how often should you update your will? I used to say whenever something major happened, if you had a major financial change in your life, if you had a family change, parents dying, children being born or dying or becoming disabled, I am now saying you need to at least think about it, look at it every 3 years. And again, the question was, how often should you update your will? The question should be, how often do I review my estate plan? And the significance of that is that we have so many things that pass outside of the will that, and they happen without your even thinking about it or even knowing about it. The big one, and I don't know how many people here have IRAs, 401ks. Generally, farmers, I think, have fewer of those than people who are not farmers. But IRAs and 401ks pass around the will. They go to the beneficiary. And I tell people that about 96 to 97% of the time, that simple beneficiary designation form is filled out improperly. Whether you filled it out yourself, or whether you went to your broker and had them, or your banker and had them fill it out, it's filled out improperly. The fine print often says, if my spouse doesn't survive me, I give it to my children or the survivor of them. And your will says, I give it to my spouse, and if she's not living, I give it to my children or their descendants per stirpes. So what the form says, usually avoid, if you have a predeceased child, you have grandchildren, and you have a predeceased child, those children of that child are disinherited by a typical beneficiary designation form in an IRA or a 401k. I asked, there was somebody in the audience one time when I gave a whole little talk on that, and I went back and sat down, and she said, and she said, I work for an insurance company. We handle a lot of 401ks. You know why we have that in there? And I said, well, I can guess, but tell me why. And she says, because that way we don't have to go looking for people. We don't have to go looking for the beneficiaries. Well, who is that for the benefit of? So I would answer the question you didn't ask by saying you ought to have your estate plan reviewed every 3 years. And if, just think about it every 3 years. Take it, if there's something happened, take it to somebody and talk to them about it. And they have changes in the law as well. Anything else? Yes?
When you talk about
okay, the question is, who decides on a standby power of attorney or for health care or financial decisions when that would be triggered? Typically, we put in the language, and I think the health care power of attorney by statute requires a statement from a physician to say that you're unable. There's some magic language that you would put in an affidavit that the physician would sign, and so the physician sometimes will say the physician and a member of the family. So you don't either have a renegade physician under the control of somebody, or you have at least somebody else other than the person, a member of the family other than the person being appointed. That doesn't work if you have only one child or whatever, but usually it's the physician. And incidentally, if you have one of those and it's more than 2 or 3 years old, it's probably outdated because the HIPAA Act requires that the physician have a release before they can sign that statement. Of course, you're disabled, you can't give them the release. Your power of attorney form should have a release attached to it, releasing the physician to give that information. Yes, sir.
What about tenancy in common?
Okay, the question is, what about tenancy in common issues with property ownership? I am a fan of tenancy in common. I recommend that instead of joint tenancy. With tenancy in common, you each own half. With joint tenancy, you each own all of it. And the tenancy in common situation means that the assets are going to pass under your will, and that's generally what you have the will for, and so you want it to do that. Now, it depends on what the asset is, and it depends on the amount of assets that you have. Back when the estate tax kicked in at $600,000, I was having people put their houses in tenancy in common. Now that it's $2 million, I look back at those people, and if they come back, I say, well, we could go to joint tenancy now because you're not in an estate tax situation. Yes, sir. Well, yeah, that's a good question. How does the changing estate tax affect estate tax law affect the $2 million amount and what happens to it? This is currently one of the goofiest laws in the state in the nation, and we have a lot of them. But this year, $2 million. So when I'm talking about your situation, I'm talking about you dying this year, or let's see, not next year. Next year it goes to $3.5 million. So you can protect easily $7 million next year. In 2010, it goes away completely. And not necessarily good news, but it goes away completely, so there's no federal estate tax if you die in 2010. And so estate planning lawyers are conjuring up all kinds of pictures of on December 31, and Dad's near death, you put him on the life support to get him into 2009, or 2010, I mean, regardless of whether he had a declaration of intention that said that he didn't want to be on life support. But then in 2011, it goes back to $1 million. So we retrace back to where it was several years ago. It was 1.5 for a while. And back when this law went into effect, it was part of the Tax Reduction Act. We were saying, there's no way this is going to happen. This will change before 2011. But here we are in 2008, and absolutely nothing has changed. The thought is that it'll go to maybe something like 3.5 million or 5 million. I mean, I don't know, but nevertheless, there's been no change so far. And one of the leading speakers in the country is now saying, I'm no longer saying it's impossible. I'm saying it's possible now. He's not saying it's likely, but it's possible. But yeah, so you need to plan, and when you're preparing a will, I mean, go back to the question: how often should you have it reviewed? Well, what year is it? You know, wills that I'm doing now are taking into account all of this, and it's a fairly sophisticated will. And I said 2010 isn't necessarily all good because you don't have an estate tax. In 2010, you have carryover basis. I don't know if anybody here remembers carryover basis. It was in the, I don't remember, 70s or mid 80s. Total disaster because you had to figure out what the basis was on the property that you inherited from mom and dad, and what did they pay for that plow back in 1935 that I'm selling now, or whatever. I mean, make up your own facts. But that's tempered, though, in 2010 because you're going to get a certain amount of step up in basis with a law that's more complicated than I care to go into. I probably couldn't even explain it, much less have you understand it. But there's some benefit in 2010 to dying, even in spite of the benefit of dying in 2010 is not overwhelmed by the carryover basis, but it is reduced quite a bit. Did that answer your question? Okay.
What do you do if you have a family member who's in denial, like you talked about? How do you jumpstart?
That's an excellent question. How do you jumpstart a family member who's in denial? I don't know the answer to that question. That is a tough one. You just keep working on it, and depending on age and health, they almost always come out of it. The denial, I mean, not the age or the health necessarily. They come out of the denial. But you can recount horror stories. You can give them literature to read. But I don't know. I just don't know. We're over. Yes?
Have an acquaintance assets title.
The asset should be titled in, let's say it's Mary Smith. Mary Smith, trustee of the Mary Smith Revocable Trust.
Automobiles?
Automobiles, we generally don't even recommend you put in a revocable trust because, pardon me? Same way. No, going back, not to not put them in. They all ought to be in there, ought to be titled the same way except for the automobiles. Everything would be the same except the automobiles. Yes. And why not automobiles? Automobiles, person dies, you can go down, they have a form at the treasurer's office, identify yourself as next of kin, fill out the form, you can transfer the thing. Plus, you have insurance issues, just all kinds of headaches by putting the automobile and the vehicles in the trust.